As an example of consideration, consider Hamer versus Sidway. In March 1869, William E. Story had a conversation with his nephew, William E. Story II. The elder Story promised to give his nephew $5,000 if the nephew would abstain from drinking alcohol, using tobacco, swearing, and playing cards or billiards for money until he reached 21 years of age. The nephew accepted the promise of his uncle and refrained from the prohibited acts until he turned 21. In January 1875, Story II wrote to his uncle and requested the promised $5,000. The uncle responded that he would fulfill his promise but would prefer to wait until his nephew was older before handing over what at the time had been an extremely large sum of money. The nephew agreed. However, before the money was ever transferred, the older Story died, and his estate refused to honor the promise, arguing there was no binding contract. As a result, a Louisa Hamer, to whom the nephew's financial interest in the $5,000 had been transferred, sued the estate. The estate was represented by its executor, Franklin Sidway, who was the defendant in this case and who is pictured here. The legal question was whether there was valid consideration to support the formation of an enforceable contract between Story and his nephew. The court decided that there was such consideration and held for the nephew. According to the court, the nephew had the legal right to engage in drinking, smoking, and other activities that were the subject of the arrangement with his uncle. Therefore, by not engaging in these activities, there was forbearance or abstaining from his legal rights, which constituted valid consideration. The executor of Story I's estate, Sidway, was therefore legally bound to deliver the promised $5,000 to whomever currently held the interest in the sum, which by the time of the trial was Miss Hamer.